Hello and welcome. I am Chakshu Roy and you're watching Laws in the Making on Rajya Sabha TV. Today on the show, we are discussing the 2020 Aircraft Amendment Bill. To discuss the bill, I have with me on the show Mr. Satyendra Mishra, Joint Secretary, Ministry of Civil Aviation, and Mr. Ganapathy Subramaniam, Chief of Bureau, New Generation Media Corporation Private Limited. The International Civil Aviation Organization sets global standards for air safety. In India, the Aircraft Act of 1934 contains provisions for safety of aircraft operations. Following audits by the ICAO in 2012 and 2015, the amendment bill seeks to give recognition to the existing regulators under the Act and increase fine for certain offences.
There are 3 regulators today under the Ministry of Civil Aviation. The Directorate General of Civil Aviation carries out safety oversight and regulatory function, while the Bureau of Civil Aviation Security oversees civil aviation security. The Aircraft Accidents Investigation Bureau is responsible for investigations related to aircraft accidents and incidents. The bill recognizes these 3 regulators, the DGCA, the BCAS, and the AAIB as statutory bodies under the Act. Each of these bodies will be headed by a Director General who will be appointed by the Centre.
The ICAO audits on safety have not been very flattering to India. You may also recall that prior to this, FAA, Federal Aviation Authority of the United States, had reduced India in the category, which is quite serious, because that gave certain disadvantages to Indian airlines going to US, Airlines of India going to US. Now things have improved over time, and ICAO audits are audit is not one specific thing. There are so many things in the audit, in an audit report, but the audit report by itself is improving. So there is an improvement in India. I would say that one of the issues which was marked out was that the controllers and the airports need to be licensed. Now that thing has also started. So the effort towards improving the quality of audits is taking place. But I will still say that India still has to improve substantially in the safety of aviation and in the safety of audit, because audit also goes into the procedure. So these are some of the things which are important.
The maximum penalty for various offences under the Act today is a prison term of up to 2 years or a fine of up to 10 lakh rupees, or both. The bill raises this limit from 10 lakh rupees to 1 crore rupees. These offences include carrying arms, explosives, or other dangerous goods on aircraft and violating any rules notified by the central government.
You see, licenses, if there was a gross violation, they were revoked. Even now the amended bill does not give unlimited power. You have to be at default in the provisions of Aircraft Act or the Air Safety Act. So there are multiple acts. If you are doing a basic violation of those norms, if your safety standards are not enough, whether it is applicable to the technical staff, pilots, engineers, or the operator, airlines, airport authority and various other agencies. So if you are not following the norms, in that situation there will be the removal of license. But now the situation is that there are more specific guidelines. It was a very vague area, what constitutes the violation. Now with the Aircraft Act, the DGC is duty bound to bring more specific guidelines, what constitutes a violation, and more focused. So I think with that the regulatory agencies and safety oversight will improve considerably.
Under the bill, the central government may cancel the licenses, certificates or approvals granted to a person if found to be in violation of the Act. Licenses are given for the operation, repair and maintenance of aircraft and the establishment of air transport services and aerodromes. Certain offences under the Act, such as flying to cause danger to any person or property, can get compounded under the bill.
Mr. Mishra, can we begin the program with you? If you can walk us through the circumstances which has led to the government piloting this bill in Parliament about amending the Aircraft Act.
It started from the audits, as you told that ICAO is an organization, International Civil Aviation Organization, who sets the standards, and they audit different regulators. So they came for the audit of Indian regulator, that is the Directorate General of Civil Aviation. The audit was done in 2012, again in 2015, and they came for the review again in 2017. During the audit, they found that there are certain provisions or the certain things which are not captured into the legislation. The current act, the Aircraft Act 1934, which is at present, the section 4A provides that safety oversight functions through a Director General and its officers. It does not mention about the Directorate General of Civil Aviation, the organizations are not mentioned. So, and then subsequently during the course, two other organizations were created through the executive order, and that was the Bureau of Civil Aviation Security to see the security oversight, and Aircraft Accident Investigation Bureau, which is another body which looks after the investigation aspects. Now all these three organizations are existing, but they do not have any legislative backing. So this is one of the reason to bring them into the legislation and to satisfy the ICAO in their audit observations, in fact. The other observation is, like in DGCA, the penal provisions which are enacted, currently there is a provision for fine as well as imprisonment, but this fine and imprisonment can only happen through the route of courts, in fact. So the DGCA or the affected person has to go to the court, and then only these fines can be imposed. So the observation was, why not the officer should be empowered who can take care of certain offences which are primarily emanating from the rule making. Like section 5 of the act has got power, it gives power to central government to enact rules. Now various rules have been enacted, and through rules the officers are functioning, but they do not have any power to take care of any mistakes or offences done by the stakeholders. So the provisions are being brought in for giving them the powers to impose penalty. Not only imposing penalty, there is a provision for the appellate proceeding also. And the other thing is, which is coming into the act, is like there are certain armed forces like border security force. So the act excludes military, it excludes naval, air force, but it doesn't exclude armed forces of union from the purview of Aircraft Act. Primarily the Aircraft Act is for the civilian aircraft. And the border security force, the organization, sometimes they require to deploy the pilots which are from the military aspect. So the military regulation and civil regulations are a bit different, and if they do not comply to the civil regulation, then they have to seek a special exemption under 160 to fly the civilian aircraft. Now there were repeated requests, so it was felt that why not bring the amendment and exclude the armed forces of union from the civilian act, in fact. So this is another aspect which has been brought in. Other aspect is the offences are there. As I told that there are certain provisions where the penalty can be imposed or fine can be imposed only through court. Now going through the court, it is a long drawn process, and litigation, if it is a lengthy process, it is not having that kind of a deterrence, in fact. So to bring the deterrence in a faster manner, It was felt that why not the provisions should be brought in the Act itself, where the offences can be compounded, and these provisions have also been brought.
Okay, so, Mr. Mishra, I'll just interrupt you there and bring Mr. Subramaniam into the conversation. Mr. Subramaniam, what is the role that regulators play in the area of civil aviation?
See, like every sector, the role of regulator is very vital and important for very balanced and buoyant functioning of that sector. DGCA, one observation that has been going on for a long time is that is functioning more like a government arm and not like a independent regulator which takes its own decisions. So there has been some comparison with IRDA or TRAI, etc. However, in this bill, what we see is the changes that are being made are more in the nature of updating the law. From past experience, what have we observed, and according to that, what changes do we have to make? Like for example, Mishra ji mentioned about the defense forces. The paramilitary forces are also being brought on par with Air Force, Navy or the Army. That is because it was found that while these three forces were included, others were not included. They should be in a same category and not clubbed with the civilian category. So that has been changed. Like similarly, other changes have also been carried out. But what probably we need to look at further is according to ICAO audit and according to other demands and experiences, these changes are being made. This is going to modernize the Act, but we need to even go a step further. For example, here we say at one place the explanation is the regulating air transport services. It is not as simple as say registration of aircraft or a prohibition of flight over any specified area. These are all very limited and very specific provision, but air transport services is a very wide area. So therefore, here it is law, then there will be bylaws and norms and guidelines, etc. So there is a scope further for expanding this and breaking up this one into what kind of stipulations, what kind of guidelines, and each person has to follow. Like for example, passengers, what are their liabilities, etc. Airport operators, what are their responsibilities, airline operators, what are their responsibilities, etc. Those can be done. That will make the law even better, and a step further will be to go for a altogether fresh draft which may suit the current modern conditions and also look forward into the future.
Okay, Mr. Mishra, taking out from what Mr. Subramaniam is saying, bringing the regulator within the, or mentioning the regulator in the name of the, within the text of the law, what does that mean when it translates to working on the ground?
See, Section 5 of the Act, it has got various clauses and it gives power to the central government to make rules. Now, it covers various gamuts in fact, and deriving the power from there, the Aircraft Rule 1937 has been made, and the Aircraft Rule also gets amended from time to time depending upon the need in fact. In the rules, the power has been given to the regulator to issue the civil aviation requirements, that is called CAR in fact. So there is a power to regulator DGCA to issue CAR. Rules are laid down, and as the need is increasing, those rules are amended, provisions are there, and the CARs are also issued. So I think it covers, though everything has not been specified in the Act itself, but giving the power through the rule part, the various aspects of the regulations have been covered.
Okay, great. We'll carry on more of this discussion after the break, but it's time now to take a break. When we come back, we will discuss the provisions for legal recourse and exemption for armed forces. Welcome back. On the program today, we're discussing the Aircraft Amendment Bill 2020. The bill converts 3 existing bodies under the Ministry of Civil Aviation into statutory bodies and increases the maximum limit on penalties.
A deputy secretary will be appointed to charge penalties under the bill. There is also a provision of appeal against the order of the deputy secretary. Courts cannot take notice of any offence under the Act unless a complaint is made by or there is a previous permission from the Director Generals of the Civil Aviation, BCAS or AAIB.
This is a new kind of a provision which is good also. They are giving some powers to DGCA and to the Bureau of Civil Aviation Security and to Airport Authority. So I think all these things are that, let the decisions be taken first at the level of DGCA, Director General Civil Aviation is an authority, and after that if people are aggrieved they can go to higher courts. So in a way, with growth of Indian aviation, which is India is going to be the third major civil aviation power soon. So we are going in the right direction of consolidating and making the functioning of DGCA and Bureau of Civil Aviation Security more important and entrusted with more powers.
These matters include inspection of aircraft and conditions under which an aircraft may be flown.
Well, I think we are becoming more conscious about the safety. Everybody is, luckily Indian aviation has been one of the most safe industry anywhere in the world, and 50 years ago we were rated among the best, though it is not the situation any longer. But the basic point is that it is an attempt to bring awareness about the safety being paramount importance in DGC operation.
Aircrafts belonging to the Navy, Army and the Air Force are not regulated under the Act. Adding to that, the bill keeps Border Security Force and other armed forces of the Union outside the purview of the Act. However, these will continue to be governed by the Act until notified by the central government.
Mr. Subramaniam, an important aspect of the Aircraft Act is the rules that are notified under it, and since these rules are extremely important for civil aviation operations, there is a current framework which is changing a little bit of that. Can you talk about it?
Yeah. See, the rules ultimately define the role and responsibilities of all the players, and also what happens if the rules are violated. Of course, the penalties have been increased now, etc. But in effect, how do we do it? Also, there is a new debate that has been started by the principal advisor, economic advisor in the finance ministry, to supervision versus regulation. Of course, regulation, and there are discussions about over regulation, but will supervision be better? Will getting people to move in the right direction but better than putting in deterrents which may prevent them from going in the wrong direction? Like for example, what happens to the entire gamut of passenger rights? Now there are rules and regulations that passengers have to follow, and they are made to follow it. What about the airlines? Are they following the same rules and regulations? Suppose your flight is delayed and because of that you suffer a very major loss. Who is going to make the airline pay for it, etc.? Those responsibilities have to be defined even further. Therefore, if in the law itself the basics are strengthened further so that it flows strongly into the rules, then it will be better. Because also there in the legal provisions it is said that when we go to the courts also, there is a role for the DGCA. The sanction of the DGCA is necessary. So that kind of a situation, we need to look at these things, especially in the changing scenario where we have things like drones, which are also called as unmanned aircraft, aerial vehicles. These, what are the things that they can cause? What kind of disruption? Are we prepared in the law for it, or how we are going to go through the rules only for that? Those things have to be clarified better.
Okay, Mr. Mishra, Mr. Subramaniam is raising the question about what is the balance between legislative powers and delegated legislation which is there for operational requirements. What do you think?
See, the power has to be there to the regulator because we are in the area of safety of the aircraft. This is aviation safety, where safety is paramount, and the power has to be with the regulator, because we cannot take any chance. Rules are there, and the regulators are from the time to time, they are doing audit of the airlines as well as the airports, as well as all the ancillary activities which are associated with the aviation sector. And whatever the audit findings, observations are found, the corrections are made. Not only that, if any pilot is found to be not passing the breathalyzer test, his license is immediately suspended. So that kind of situation is there. We cannot take any chance, and the regulations are being implemented in a very proper manner. As far as Mr. Ganapathy's observation on the upcoming areas of the drones and other things are concerned, the primary regulation in the rule is already there, as the drone is also falls within the definition of the aircraft itself. But the ministry is already in the process of having the separate rules for the drone activity, and we are thinking much ahead when this drone is going into the beyond visual of line of sight and the autonomous environment. So how in next 5 to 10 years these situations can be tackled, the work is still in the process.
Okay. Mr. Ganapathy, an important aspect of this current legislation is providing an exemption to the Border Security Force and to other forces of the Union. And this exemption was already available to the Army, the Air Force and the Navy. Can you talk a little bit about that?
Yeah. See, intelligence wings of the government also use aircraft for specific purposes. And also now increasingly we see Coast Guard and Border Security Force. Now even CRPF also, there are requirements for aircraft from their side as well. And their role also has changed now as compared to what used to be there earlier. The traditional role of the Army, Navy and Air Force is on one side, and the evolving role of these paramilitary forces is on the other side. So therefore, bringing them at par with the other defense forces is will do justice to them, will allow them to function more independently, etc. But at the same time, care should be taken that all of them are unified in such a way that the entire sphere of defense or non-civilian airline activity is kept in one separate silo, and the civilian activity is in a separate silo, which requires a different kind of a treatment.
Okay. Mr. Mishra, in the last part of the program, one of the things that you touched upon earlier, and I want to bring you back to it, is the compliance of the law and the role that penalties have to play in that. If you can elaborate on that a bit.
Yeah, penalties have a big role in fact, because right now there is no deterrence on account of any financial aspect. At the most, if some violations are done, you can cancel the license, or you can cancel the certificate or the approval whichever has been granted. But there is no immediate financial loss to any or deterrent to any stakeholder. By bringing the penal provision, such offences can be tackled in a faster manner. Like if you cancel the license of, let us say, airport or airline or maybe some pilot, that's not a very good aspect for the industry itself. If you ground the pilot for 6 months or maybe 2 years or 5 years, he's an skilled person. But if the penal provisions are there and they have got the fear of that, okay, the financial loss can occur to them, probably they will be careful, and the long litigation process which is inbuilt through the court route, that will not be required. And like Motor Vehicle Act, there is a provision for compounding of offences. Similar compounding of offences we are bringing into the Aircraft Act.
Can you detail that a bit as to what do you mean by compounding?
Compounding means, see, there are certain penalties which will be imposed if there is a violation of rule which has been made by the government. But there are certain other penal provisions which are independent of the government rules. They are primarily given into the Act, like section 11, 11A, 11B and under 10 also. Now such offences right now can be dealt only through the court in fact. But if such kind of offences are also there, and the regulator has got the power to compound it. Instead of going to the longer route, those offences can be dealt in a faster manner.
Okay, so what you're saying is, if there is a violation of a particular rule, rather than go through the protracted process of adjudication through a court, the regulator can ask the offending party to pay a fine or do other such activity and close the matter there and then and move forward.
Yes.
Okay, Mr. Subramaniam, compliance of law requires some kind of a penalty. The other in the Act, currently the penalty was capped at 10 lakh rupees. Now that the financial aspect of that penalty has been increased quite a bit. What do you think?
Yeah, definitely, it's a very good move, and I think this should be put to good use. Say for any airline that is found to be wanting, or any airport operator who is found to be lacking in following the rules, I think these new rules should be applied, and probably in a strict manner. As Mr. Mishra said, that see, if there is no fear of any kind of immediate impact, then people go to the court and they think they will take time, etc., etc. But if there is a fear of an immediate fine, especially a commercial organization like a airline company or a airport operator would fear that, because within the organization there will be questions asked, who is responsible for this lapse?
And perhaps that will lead to compliance of a better legal framework. Thank you, Mr. Mishra. Thank you, Mr. Subramaniam, for joining us on the discussion. It is time for us to end the show. You can watch our shows on the RSTV page of YouTube. We will be back with a new issue and a new episode. Keep watching Rajya Sabha TV.